Our next case set for argument this morning is State of Ohio versus Thornton Thomas, case number 29124. State of Ohio has waived oral argument, so we will just be hearing from Attorney Medvick on behalf of Mr. Thomas. You'll have 15 minutes, and we've read the briefs and are ready to proceed if you are Attorney Medvick.
See if we can get through this without glasses. I'd rather see you than whatever right here. Good morning, Your Honors. Please court, I'm Alan Medvick. I'm here on behalf of the defendant appellant, in this case, Thornton Thomas. Mr. Thomas has raised two assignments of error, three issues regarding the insufficiency of the evidence and regarding the failure to merge the two counts of felonious assault. I think I'm going to address these in reverse order. Let's start with the issue of merger. I wanted to be clear because it seems that in the state's response, you seem to think I was asking for those charges to merge with the counts of aggravated robbery and burglary. I am not. I am simply contesting that those charges he should not have been sentenced under both of those counts of felonious assault. Now I understand that when you review the record, you also find that he is charged and sentenced under both of those counts, but those sentences are running concurrently. So to address the issue of harmless error, that is not the case in the majority of districts in this court. Because the acts, in our opinion, are a single act and not separable, there is a prejudice to being found guilty of two offenses, even in the case where they are sentenced concurrently. The 8th, 10th, 1st, 11th, and 4th have all addressed this issue. State versus Sullivan, 2003, Ohio 5930. State versus Crowley, 2002, Ohio 7366. State versus Lang, it's older, 1995, 102, Ohio at 3rd, 243. State versus Haynes, 2005, Ohio 1692. State versus Shaw, 2008, Ohio 5910. All of those address this specific set of facts where failure to merge, despite concurrent sentences, were found to be a prejudice to the defendant. The basis for that is that would have an effect to reputation in finding a defendant guilty of two offenses for a single act. The merger here is based on the fact that this is a single act. It is stated in the most recent case on what is a continually shifting issue regarding merger, State versus Jackson, cited in my brief. There are three elements that have to be shown: that the act has that the acts of similar report, that there's no separate act, and that there is no separate animus. Those are the three things that must be shown to find that they are the same act. The state points to State versus Ruff, which asserts that because of different victims, that would preclude merger of these acts. In this, I would argue that State versus Ruff involves separate acts and separate offenses. That involves a burglary into one person's home, which subsequently ended in a rape of another person.
But isn't there a lot of precedent on that issue that's separate
And
victims?
I don't believe in this case, not in a single act, and I believe the Jackson analysis after Ruff would preclude that.
So Jackson, remind me, were there separate victims in that case?
That I am not sure at this time. I apologize. But I believe that in this case, regardless of there is one single act, and I have not found a case where, obviously the case law in this district is pretty clear that and when I speak of a single act, I'm talking about a gunshot, and in this case a single gunshot. I am not disputing, and the case law is clear out of this district and probably statewide, that if you fire multiple shots out of a gun, the separate victims issue becomes a matter. Here we have undisputably one single shot fired from one gun. We have one bullet that is being tested to causing harm to two people. I don't know that analysis holds up. I would argue that it does not. I think this is essentially the swinging of one baseball bat. This is a single punch. This is a single act that you're now trying to Either it was directed at Mr. Menard or it was directed at Ms.
But doesn't the felonious assault statute itself encompass causing or attempting to cause serious physical
But
harm?
I'm saying that how do you distinguish, regardless, it either is meant to hit Mr. Menard or it's meant to hit Ms. Crandall. I don't know that you can get to, we've got one bullet, I mean, and
What
outside.
if he missed both of them?
And I would still contest that that would be a single act, and that attempt would also have to merge as to both parties. I think that I'm not disputing that the success of that, and the fact that you get one, I think that might make it even clearer that you can't attribute a single missed shot to two different people.
Okay, so 2 counts of felonious assault for the purposes of sentencing merge.
For the purpose of the
Okay.
sentencing, they would merge as one.
Okay.
That is the argument here, and that's where I believe that there was error. On to the second point, which is the relating to the felonious assaults themselves and finding that Mr. Thomas was complicit in, who has been now identified, or is identified in that case as Mr. Jones' act of firing the gun. That in this case, the evidence is undisputed, and the state does not argue that Mr. Thomas fired the gun. That's not disputed in any way. The argument is that because Mr. Thomas was present at the time the gun was fired, he was complicit in that. I don't know that, and I think that the prosecutor and the trial court take an overly expansive view of complicity in this case. As you know, complicity requires an identical mens rea to the act of the principal offender, in this case, which would be knowledge, and in that case, he had to knowingly solicit or procure, aid or abet, conspire, or cause an innocent to cause the principal offense, which is felonious assault, to cause or attempt to cause physical harm to another. There is nothing in the record to indicate that Mr. Thomas had any knowledge or took any part or took any affirmative act that Mr. Tyler Jones was going to pull that gun out of his pocket and fire it at any part, or that he abetted or assisted in any way in that shooting, or even in the escape or the acts after that event. The felonious assault, or the robbery and the burglary, he was an active participant in, according to, accepting that to be true, accepting the identification of, which is point number 3. Accepting that Mr. Thomas was there for the aggravated burglary and the aggravated robbery, that he was a person on that scene. There is still no evidence that he was complicit in the shooting of Mr. Menard or the attempted harm to Ms. Crandall by Mr. Jones.
Well, Counsel, if we could set the scene a little bit about what the record reflects. Were they, I seem to remember reading something that they weren't fleeing from the scene of the first crime in a quick manner, that they were just kind of walking along out of the house with their...
They were walking out of the home. There was some distance between them when Ms. Crandall and Ms. Menard confronted them as leaving.
Does the record reflect what is said to them?
And the record indicates that Mr. Menard and Ms. Crandall confronted them and told them to stop, I believe is what will be indicated. And at that point, the smaller man, who was later identified as Mr. Jones, turned and pulled his gun and fired. The testimony of both Ms. Menard, or Mr. Menard and Ms. Crandall is that Mr. Thomas, assuming it's Mr. Thomas, did nothing in response to that. He did not say anything. He did not act in any way. He did not attempt to pull a gun.
And at some point, someone is carrying a computer?
There is, I believe that Mr. Jones was the person whom they testified had the backpack in his possession.
Drops that, right?
Yes.
And then they actually
And then after
speed up their
the
exiting.
after the gun is fired, they leave. And I think that all that has happened at that point is that they fled the scene. But there is no.
Together? Does the record
The record is unclear. I think the state attempts to argue that they fled together, at least as far as the sure that that supported either questions about the hat, but we'll get to. But that said, I think the mere act of departing, he was not a car driver, he did not attempt to support Mr. Jones in the fleeing.
So your argument is the first crime is over completely,
Yes.
and then
I
there's the
think that
second.
there's a clear break, and I think that the trial judge, Judge Rollins, I think she attempts to claim that it was reasonably anticipated that after this burglary was concluded, where no guns were fired, where there were no shots fired, where Mr. Thomas did not fire a gun, although the evidence is clear, it's Mr. Thomas. He did have a gun that he had out at that time. But that after that was done and they were leaving, that Mr. Thomas had knowledge that Mr. Jones would shoot someone, and I think that is going a bit far based on the complicity case law in this state. And that might be understated. I think that that's not supportable by the law. And lastly, as to the identification issues with the larger suspect in this case, Ms. Crandall states that she walked into the home, saw a man in red, white, and blue Nikes, and then left the home and was later driving around and saw a man in Timberlands that she identified as the shooter. She saw a man in purportedly yellow rock revival jeans, which is another point that we would get to, because none of the police officers recall that being testified to at the time of the report. The person who was subsequently identified by Ms. Crandall was wearing sweatpants. The other witnesses are all over the map regarding what the parties were wearing, what their clothes were. Mr. Bernard, when he was outside, believes that they were black jeans and black shoes. Mr. Kirksey goes back and forth that the smaller man was wearing red, white, blue Nikes, and the larger man was wearing Timberlands. They are inconsistent at best, and I think one of the things is telling, and Ms. Crandall eventually becomes, in her testimony, is very adamant about the rock revival jeans, but what is also clear in her testimony is that she had met with the police officers, or with the prosecutors at least twice prior to her testimony, and describes having been shown photos, and the way she describes them, and I'm in no way claiming that the trial counsel should have raised a sense suppression issue or anything, but if it had been a photo array for people, or if this had been an attempted identification of a suspect, I think it would have been stricken as because what essentially happens is if I'm reading the record correctly, as Ms. Crandall describes it, she's shown a photo of a pair of pants and says, are these the pants you saw on a man? Which, if that was I'm not asking for a pants photo array, but I'm saying that you certainly have to call into question the nature of that. If you were shown a pair of pants, these are the only pants you're shown, these are the pants you know that the person who was arrested was wearing, you are inclined to say those are the clothes that I saw. And I believe, given the testimony, that whoever, that at the time, none of the officers recall a description of yellow jeans, of rock revival pants. All they testified to is the fact that these were blue jeans. And that's what they recall hearing from Ms. Crandall at that time. This prior inconsistent testimony, along with the fact that the person who was subsequently arrested was not dressed the same. That she also identified a smaller gentleman whom she believed to be the man on the scene who was not and was subsequently exonerated from the case. I believe the state, and this was not the first call she had made that evening. The state describes that Ms. Crandall was not just driving around identifying everyone in Akron,
30 seconds.
I would argue against that. I would say that it's quite possible that she was looking for anyone who fit this description. And then I think she found someone, and then he was subsequently arrested for that. And I don't think that is sustainable. And I would ask that this court acquit based on a Rule 29 finding. Thank you very much.
Thank you very much. We'll take the matter under advisement and issue a decision in due course. And the clerk of courts will mail you a copy of the decision on the day it's released. Thank you for your arguments.
Thank you.